We have only one substantive item on our agenda today, and that is Stage 1 evidence on the Coronavirus Scotland number 2 bill. Before we come to that agenda item, I would propose that we take agenda item 3 in private. I hope that all members agree with that. If any members disagree with taking that in private, can they indicate now, please? I'm not seeing any disagreement, so we can take that as agreed. Thank you. We're now moving on to agenda item 2, which is evidence on the Coronavirus Scotland number 2 bill. And I'm pleased to say we're joined this morning by Michael Clancy, who is the Director, and Gillian Maudsley, the Policy Executive from the Law Society of Scotland. And at this point, I should probably remind members of the committee that in my register of interest, it says that I am a member of the Law Society of Scotland. So can I welcome both Michael and Gillian to the meeting. And Michael, members will direct their questions to you in the first instance. And if you wish Gillian to contribute, then if you just confirm that at the relevant time. Before we turn to questions, I'd invite Michael Clancy if he wants to make any brief opening comments.
Good morning, convener. Good morning, committee members. It's a delight to be here in this historic event, the first time that evidence has been given from our best parlour here at home. And I'm delighted that the committee saw fit to invite the Law Society to give evidence on this important bill, the Coronavirus Scotland number 2 bill. Gillian Maudsley, my colleague, is the policy officer in the Law Society, and I am the Director of Law Reform there. And consequently, a lot of the coronavirus legislation has come across both of our desks, and we've been extremely interested in that legislation from a number of perspectives. The Law Society works to a number of principles when looking at legislation. Firstly, that it should end up as good law, which is coherent, comprehensible, and works in practice, and also in these particular circumstances of the legislation relating to the COVID-19 crisis. We have been seeking to ensure that people are kept safe in the justice system. We've also been looking at maintaining the rule of law and the interest of justice in that system, and the upholding of human rights too, and particularly when we're dealing with emergency legislation or even expedited legislation such as this bill, there is the objective to keep proper scrutiny of that measure and make sure that government is held to account. So those are the sort of introductory parameters, convener, which we've been working to, and we can look at those in further detail as we go through questions on the bill. I think it's worthwhile recalling that the World Health Organization's Director General, Tedros Adhanom Ghebreyesus, said, "We're in this together to do the right things with calm and protect citizens of the world." That's a quotation which we picked up early on in our scrutiny of the first Coronavirus Act in the United Kingdom Parliament. And I think that message still resonates today when we have seen much more of the significant impact which this disease has had with its tragedies and its devastating economic impact as well. So that's, I think, probably enough from me at the moment. We'll be delighted to receive the committee's questions. Thanks.
Thank you, Michael, and thank you for that introduction. You mentioned there the first coronavirus Scotland bill that the Law Society gave evidence on. And at that point, you highlighted a number of concerns about whether the right balance had been struck between measures to tackle coronavirus and restrictions which might impinge on human rights. So I wonder, in the context of this bill before us, whether you think this bill has struck the right balance, or whether there are areas of concern where you think changes are needed.
Thank you, Convener. I think this bill is a much more technical and less wide-ranging bill than the first coronavirus Scotland bill. And so therefore, the impact on human rights is not, how dare I say it, of the same order as some of the proposed restrictions which were contained in the original bill. Nevertheless, clearly ECHR, the European Convention on Human Rights, is engaged in many areas in the bill, and I think it's important for us to remember that human rights is not just a discrete area of the law, but affects all aspects of the law in Scotland, and of course the competence of the Parliament to legislate and ministers to make executive orders. We welcome the way in which human rights are respected in the policy memorandum, for example, and we can highlight some of the provisions of the bill which engage the Convention. I just held up the bill just to show that I'd actually got a copy, because the compliance with ECHR and convention rights flows right the way through the bill. If I were to take aspects relating to the first schedule, where issues relating to student residential tenancy are discussed, then those engage Article 14 of the Convention and Article 1 of Protocol 1 of the Convention, which deals with property rights. In bankruptcy matters, there is also an engagement with Article 1, Protocol 1 of the ECHR, and in provisions relating to criminal justice, questions in respect of Article 5, the right to liberty, and Article 6, right to fair trial, crop up. And as we go through the bill further, then we see that in Part 3 of Schedule 2, where there is discussion about the use of paper notices on court walls, then Article 8, the right to a private life, is engaged. There are some aspects of the bill which the policy memorandum correctly points out have no significant ECHR implication. For example, Article, or rather Schedule 3, Paragraph 1, which deals with reports under the Climate Change Scotland Act 2009, and other elements of that provision in the schedule, in Schedule 3 and 4. So I think it's fair to say that there is an impact on human rights in the bill, but in many respects, because the nature of the rights impacted are not absolute rights. They're conditional rights in some respects, subject to lawful interference in instances where there is a public health threat or a danger to health. And I think that that's probably where we would comment on the human rights interaction.
Okay, thank you very much, Michael. I'm going to move on to questions from members. I think Shona Robeson has just joined us, so I think I'll let Shona just catch her breath, and I'll go to Beatrice Wishart first of all, and then I'll come back to Shona just after that. So Beatrice, if you're there, I think you've got questions around property transactions, please.
Thank you, Convener. Good morning, Mr. Clancy. Yes, my questions are around the land and buildings transaction tax. I mean, we know that the property market in Scotland's frozen up and transactions have stalled and homeowners are unable to move. And the Scottish Government's issued guidance to say that no one should be contemplating a home move. And even though some applications for registration are being processed, capacity is very much reduced. The bill proposes that the time frame is for selling an old property before attracting the second home tax is extended from 18 to 27 months. Do you have an impression from your members on what the mid to long-term outlook is for the sector?
We are conducting, or have just finished conducting, research, Ms. Wishart, on the impact of coronavirus on the profession and our business. And what you said about the conveyancing market being flat is certainly something which we have picked up on in that research, although the research has not yet been published. But we're still working on analysing the results. But that is clearly something which reflects everyone's experience in the current market. I think in terms of the impact on, particularly on land and building transactions tax, it's difficult to say where the correct point for any deferral date is picked as right or not. We are all in uncharted waters here. We do not know what the effect of the disease is going to be. We are aware that scientific evidence suggests that any loosening of restrictions may create a second spike, which may then, in its turn, require further restrictions. So I think we've got to be very cautious about picking a date in the future and saying that is it, that is when all of these restrictions will be released. So therefore, that's one of the reasons why some aspects of the bill which allow ministers to make orders which they can then put to sleep and revive again are important. There needs to be that flexibility in lawmaking which applies here. We welcome the provisions of Schedule 4, paragraph 5 of the bill, which concerns those amendments to the ADS, the Additional Dwelling Supplement, to allow people to have the provision where if they bought a new house between September 24th, 2018 and March 24th, 2020, and paid ADS on that purchase to reclaim the ADS if they sell their old house within 27 months. It might be the case that ministers will have to look at that again, and that's why, of course, we have the 2 monthly reviews, because this is a fluid situation. I hope that answers your question.
Yeah, that's very helpful. I also think it would be interesting to see the research when it comes to conclusions. I'm conscious that at the best of times the market in rural, remote and indeed island areas can operate at a very different pace from the highly populated parts of Scotland. Are there any areas where you might expect property markets to be slow, and how do you think this bill can best prevent people who have a genuine interest in selling their old home and are making every effort to do so from being caught out in the slow market and the additional dwelling supplement?
I think we have to adhere to the Scottish Government guidelines on this. The restrictions on movement clearly have a significant impact on buying and selling property, no matter where that property is located. And I'm not sure that we've got to a point where the Scottish Government is in a position to refine the application of those guidelines to rural areas, small town areas, suburban areas or urban areas. I think we've got to be aware that those restrictions are in place, and adhere to them. So therefore, I wish I could offer you some fantastic solution to this, but I cannot.
Thank you for that. I think we all agree that we are certainly in uncharted waters and unprecedented times. So that's my questioning, convener. I'm conscious that there are others who've got plenty of other questions, so I'll call that a day at this point. Thank you.
Thank you.
Okay, thank you, Beatrice. Next on my list is Shona Robeson, who has questions around carers allowance and some of the mental health issues. And after Shona, I'll come to Annabelle Ewing. But Shona first, please.
Good morning. I wanted to, first of all, ask you about Schedule 1, Part 4 on mental health, and in particular the nomination of named persons. So, as you'll be aware, there's a temporary removal of the necessity to have nominees' signatures witnessed by a prescribed person. Removes one of the safety checks against someone potentially being coerced into nominating a particular named person. And I guess it was really to ask whether you have any concerns, and what assurances are there that the nominator has not been coerced into nominating a particular individual to be their named person, perhaps someone who has not the best intentions, and without the presence of a prescribed person, who would explain the role and implications of nominating a named person to the nominee. So really just to get your views on that, please.
Thank you very much indeed. The Society's Mental Health and Disability Committee looked at this provision, and they came back saying that this paragraph, which amends the Mental Health Care and Treatment Scotland Act 2003 to ensure that the nominated person's signature will no longer be witnessed by a prescribed person. That this is actually a pragmatic solution to the potential difficulties of arranging for a prescribed person to witness a nominated person's signature during the current outbreak. The committee thought it's important that individuals remain able to nominate a named person subject to appropriate safeguards, and that this nomination is recognised. The policy memorandum at paragraph 82 confirms that in the view of the government, the convention rights are not engaged here, and I think we were, broadly speaking, content with those provisions and didn't see that much difficulty with them.
Okay, that's helpful. Thank you. I don't know if you have any comments on the carers allowance supplement. If so, that would be helpful. But I also wanted to ask you about the issues relating to the extension of time limits in criminal proceedings, obviously covering things like appearance in court from police custody, undertakings to appear in court, and whether there are any human rights issues or any difficulties that you have identified with any of those, and whether you have any comments on carers allowance supplement as well.
I'm awfully sorry, but we don't have any comments on the carers allowance supplement. But my colleague Gillian Maudsley is best placed to comment on the criminal justice matters, and so I would like to pass to her.
Okay, thank you.
Thank you. Thank you.
Thank you, Michael. Yes, there are a number of changes being made to time limits in this bill. Largely, they follow the changes to time limits for court business that were contained in the first COVID bill. But you asked specifically if we had any concerns. Fundamentally, they are there to make it easier to reduce the number of court hearings, to reduce the people that have to come to court, and they are to a large extent pragmatic and non-objectionable. However, as you're well aware, the whole purpose of time limits in criminal proceedings is to ensure that the human rights aspects, the right to a fair trial, the Article 6 that Michael mentioned, is respected, and the rights of the accused in not having long, drawn-out, uncertain future. So there are different time limits that are being extended. The ones to do with what I'd call a procedural matter, continued without plea, the section 145 and 145A are fine. These are kind of administrative procedural hearings and don't cause a concern. They don't affect somebody that has been effectively in custody. However, the other two that relate to medical reports and to the community breaches of community payback drug treatment testing order, fundamentally what they're doing is allowing for these matters to be continued at the court's discretion. Per se, not objectionable, but we would have concerns about the open-ended nature for people who are remanded in custody. So we would suggest that though it is perfectly reasonable provision to look at the time periods, they're there for a purpose, and perhaps when considering the bill, there might be a finite period put or some respect on the court's discretion. Just to add to that, I think we're perhaps one stage slightly further, two stages slightly further forward. We've all talked about uncharted territory. We've talked about flexibility, and totally respect that on the one side. But I think we're perhaps looking at something that's not going to be done and dusted in a short period of time. So perhaps considering whether, in fact, a finite period should be put on remand to provide certainty and clarity is something that perhaps I would encourage to be considered, but again, respecting the need not to have repeated court appearances, perhaps difficulty from doctors or psychiatrists giving necessary reports, pressure on social workers, etc., social distancing with respect to work. I hope that maybe helps your consideration.
Yeah, that's very helpful. Thank you.
Thank you.
Okay, thank you. Thank you, Shona. Next, a question is from Annabel Ewing, please. I think there's questions around proceeds of crime issues and court notices. And after Annabel, I'll bring in Stuart Stevenson. But Annabel first, please.
Thank you, convener.
Sorry, might I say before you begin, Annabel, that I would pass this question to Gillian Maudsley as well. It's more in her remit than mine.
Okay, I have several questions, but I will on proceeds of crime. I was going to just make the important point before I forget that I too should refer to my entry in the Register of Interest, wherein I'm a member of the Law Society of Scotland and hold a current practicing certificate, but I'm not currently practicing, so I just wanted to, I'm sure I remember to get that in. We start with the proceeds of crime. So basically the approach is to allow the coronavirus to be treated as an exceptional circumstance, which presumably is, but for the purposes of the legislation, such that confiscation hearings can be postponed, and indeed the time to pay, if you like, on the part of the individual can be extended. And I'm not saying that that's not reasonable, because I understand at the moment that it's actually to process matters such that you could arrive at a confiscation hearing is rather complicated by the fact that court hearings are, not taking place in the way that they would normally do so. You would require to have Crown and Defence agents and so forth. So I understand the reasoning. I just wondered if you had any thoughts about to what extent any possible evasion is facilitated by further extensions.
Thank you, Mrs. Ewing. We looked at these provisions and we thought they were substantially sensible in all the circumstances. You yourself have touched upon the aspect of perhaps clarity of the law by stating that, COVID-19 circumstances would be exceptional. That at least takes away from what would appear to be a technical, it would be required to be looked at on a case-to-case basis. So I think that clarity is clear. and that's certainly understandable. I think it's important to stress that the proceeds of crime mechanism, if we call it that, will still be in place. All that is being attributed is that there will be afforded delays where those people subject to proceeds of crime may suffer the adverse effects of COVID in trying to either pay or extended periods for payment. I think it must be stressed that these proceeds of crime, which are terribly important and very important within the criminal justice context, because a lot of the penalty comes in proceeds of crime rather than necessarily the actual conviction, and it is important that they pay their due. It won't go away. All that's happened is that they're being afforded, if you like, a degree of leniency where they too are inhibited, perhaps from the points that you discussed earlier about selling property, about realising assets to pay this. And it would seem somewhat unfair if they were suffering the consequences when we are already fully aware of the full impact of COVID on all economic matters, financial matters, etc. But I stress the whole point is that they don't go away. The confiscation order will still apply. It will still require to be paid. I'm not sure if that answers fully your question, Mrs. Ewing.
Well, thank you. It does, and I do see them as the provisions as reasonable. And I suppose it is fair to say that whilst, for as long as there are difficulties in the conveyancing market, then it would apply to everybody by and large. But I think it's something that should be looked at, going forward very carefully, because I think in Scotland there has been a great success with proceeds of crime confiscations, and it would be a pity if we, after we get to the new normal, whenever that may be, see any backtracking in that. I don't know if Gillian wanted to come back in.
I don't really say anything other than totally support what you said, Mrs. Ewing. I think it has been a major success, proceeds of crime. I have myself been involved in these aspects years ago, and it is viewed by, I think, some of those convicted as much more onerous than perhaps a conviction in prison. So I would not like to see any a takeaway, but I understand that Crown Office were totally in support and in fact had been part of, I think, identifying the need for these changes. So the legislation remains and it will still be effective. As I say, it would only be people that are perhaps affected by COVID-related circumstances that would find themselves in the position either of extensions or indeed are postponed payments or postponed interest payments.
Thank you. If I may ask Michael Clancy the other question, Rena, and that, in fact, picking up on a point that Michael raised when talking about the engagement of Article 8 and intimation on the walls of court. In particular, there's a requirement to intimate the petition for executive dative and commentary cases on the walls of court. And in other circumstances, that can also be an option. And the bill would rather require this intimation to be made by way of the Scottish Courts and Tribunal Service website. If Michael could give his initial thoughts on that provision, that would be really helpful.
Thank you very much for that interesting question. I think it is right that we now move to a position where these documents which are placed on the walls of court are placed on the virtual walls of court, as it were, the Scottish Courts and Tribunal Service website. Of course, there is an issue around the preservation of the right to private life and protection of data. Of course, the courts and the Scottish Courts and Tribunal Service are bound by the Human Rights Act and by the GDPR to protect data and to adhere and comply with Article 8. I think that this is, of course, sometimes done at the moment where documents relating to family life may have important and private matters in them, those are not then put on the walls of court. They're retained as private documents just now. And I would expect the same kind of approach to be taken by the courts just now. And the provisions of new section 1A(2), which allows that this publication on the website does not apply to a document if it is of the type that the Lord President of the Court of Session or the Lord Justice General, same person, different offices, has directed that it should not apply. And of course, that would mean that perhaps either the document does not go onto the website or that some of the information on it is redacted. So I think there are sufficient safeguards for individual privacy embedded in Section 9 of the bill, and I think we can rely on Lord Carloway to exercise this direction power with those thoughts in mind.
Thank you. By way of a supplementary to that question, I'm taking very much cognizance of the right to privacy issues which are engaged, but looking to the new normal of our lives, whenever that happens, it may well be that some of these things, including electronic registration at the Register of Inhibitions and Register of Judgments, for example, that some of these things, putting things on the SCTS website, may be a better way to do some of this in the 21st century. Have you any thoughts on that from the Law Society's perspective?
Well, I'm not sure that people would describe me as a modernizer, but I recognise the important role which the internet and all the other forms of media play today in people's lives. And it's important that the courts and other public administration offices move along with that flow. So this change may become a permanent change for the future. It's bound by the same limitations which the rest of the provisions of the bill are bound. So it applies until the 30th of September this year, with a potential extension to the 31st of March next year, and then to the 30th of September next year. So I think that we may see these sorts of changes being adopted once this period is over, looking on this period as a kind of trial period for how this kind of thing works. But it's entirely in keeping with the modernisation of procedure and process, which started with the Gill reviews a few years ago, and which Lord Carloway has pushed forward with as the legislation has bedded down and changes have been taking place. So can I predict that that will be the way of the future? Probably.
Thank you. That's me.
Okay. Yeah, thank you, Annabelle. Okay, we'll move on to Stuart Stevenson, please. I think there's some technical questions, mostly, Stuart, and after Stuart Stevenson, I will bring in Ross Greer. But Stuart first, please.
Given his introductory remarks, I have a faint feeling he may direct this towards Gillian, but here goes. Let me start with the electronic signature of forms in the bankruptcy part of this legislation. All well and good, but in particular, what it does at 10(2)(b) by an insert into previous legislation, it says it includes a version of an electronic signature which is reproduced on a paper document. And the various references backwards to, for example, the 2007 2000 Communications Act Section 7, which makes no reference to ever taking an electronic signature and putting it onto paper, and also to the Bankruptcy Scotland Regulations 2016, which at Section 2.2 again talks about you being able to use electronic in substitution for paper. This appears to be the first legislative attempt to substitute electronic with paper. And I just wonder if the Law Society has any concerns about that. Now, let me explain my concern, which might give context. That what it specifically says in the 2000 Act is an electronic signature incorporated or logically associated with particular electronic communication or particular electronic data, and the certification by any person of such a signature. But the certification is an electronic signature, which involves looking at every single dot, comma, number and letter in the electronic document thus being signed, together with an electronic piece of information uniquely known by the signer and a computation which is in the public area. In other words, when you put it on paper, you lose that electronic connection between a big number, which is the electronic signature, and what might be on that bit of paper. You could change a number and not know that that has happened. Has the Law Society thought about this, what seems to be novel, and I use the word in a non-endorsing way, move to allow electronic documents to be put on paper and have the same validity as the previous electronic one?
I did have an agreement with Gillian that matters which related to bankruptcy would be passed to her, but this is much more particular than the generality of the bankruptcy provisions. So if you don't mind being disappointed, Mr. Stevenson, I'll attempt to answer your question by saying that this particular provision does not appear to have been considered by our electronic or IT committee, but I will ask them to look at it. Certainly, if we are talking about electronic signatures properly so-called, then I agree with you. It seems to be a novel, perhaps even in some respects could be described as a retrograde step to try to then replicate a version of an electronic signature which is reproduced on a paper document. So that then makes me question what the drafter thought when the phrase electronic signature was used. And I'm sure that you and other members of the committee will be aware that some people advance the idea that an electronic signature, which I believe is an erroneous idea, is my signature scanned into my wet signature scanned into a letter which then goes into the internet. That may be a version of an electronic signature, which is referred to here, and perhaps we need to ask the Minister what he thinks the phrase "a version of an electronic signature" means, and you'll get an early opportunity to do that.
I suspected that might be the character of the answer I would get. Like you, Michael, I think the reproduction of an image of a wet signature is perfectly proper and reasonable in using this way. But the difficulty is the actual referring back to the Communications Act, where Section 7 makes it very clear by the requirement of certification by any person of such a signature that such certification is by context an electronic certification. that the image of the signature on its own is not sufficient in the context of how that act. But that's an observation, and I will not ask you to comment further, because I suspected I was going to have to ask the Minister on this. However, it would be helpful if your appropriate committee were to consider the matter. It's always difficult when you have to dive down into various previous bits of legislation and tie it all together. And mere lay people like myself are quite easily confused on the matter. I just had a very technical drafting issue, which again you might defer to the Minister on, in the student residential part of the bill, Schedule 1, Part 1. Just simply where it's talking about how a tenancy may be terminated. And I just wondered, in reading it, because it talks about references in this part to the landlord are to any of these persons, and then it says in the next section, references in this part to the tenant are to all of these persons. I read that as meaning that all the persons who are party to the tenancy have to provide notice, but any single person who may be part of the landlord's stay may be receiving this, it may be sufficient to give effect to it. Is that the meaning of what the drafting says?
Excuse me, I have to confess I did not turn my attention specifically to paragraph 1, 2 or 3, but you're correct that there is a distinction made between the notification in a case where 2 or more persons jointly are the landlord, where 2 or more persons jointly are a tenant. References to the tenant are to all of those persons. I think probably the reason for spelling that out is, as members will be aware, under the Interpretation Act, the singular includes the plural in ordinary terms. So therefore, a reference to a single landlord, that might be a company, a partnership, a joint venture of some description, but has a sense of corporate identity in one sense, particularly if it's a partnership or a limited company, that the landlord would be a single entity, and therefore any of the components of that single entity who are operating as the landlord could be notified. Whereas for 1.3, 2 or more persons jointly are the tenant, then of course one would expect that tenants are not actually working in some kind of corporate environment. They are operating as individuals, and so therefore one would think that if flatmates decided that one flatmate would give up the tenancy but the other would not, then it would cause difficulties with the continuity of what agreement there was and the responsibilities which adhere to that agreement and to the individuals who are parties to it. So it's a good question, and I think you're right to highlight this as being something which is not an error, it's not a mistake, it's a deliberate approach to make sure that the tenancy does in fact come to an end, full stop, for everyone.
Okay, thank you very much, Stuart. I think that's your questions concluded. And now we'll turn to Ross Greer, please, and after Ross, it will be Monica Lennon. But Ross Greer first, please.
Thank you, Convener. The areas that I'm interested in are around the criminal justice aspects of the bill, and they've been largely covered in answer to Shona Robeson's questions. But I would be interested in your specific thoughts around the arrangements for the custody of detained persons at police stations. And if you're content that there's enough clarity around the transition in the role of custodian between prison officers and police officers for the purposes of having those detained at police stations, for example, to appear for court appearances.
Thank you very much. And in accordance with our pact, I will pass that to Gillian.
Thank you. Yes, Mr. Greer, you've highlighted a very important aspect of the criminal justice system. And as many of you will be familiar, the trial starts in the police station. So it's absolutely essential, before even considering all the provisions that the committee and the Parliament have been considering, that the processes at the police station are safe from everybody concerned. And you have picked out one aspect, which is the use of prisoner custody officers. We understand that is entirely to facilitate the remote access of people who will no longer be required to be taken to court to appear. And that's obviously very important. And the largely technical revisals to the 1994 Act are to take account of the prisoner custody officers undertaking these duties, quite correctly, to free up the police officers to do other things. So that aspect of the bill is fine. I would just highlight that there are ongoing discussions with regard to facilitating the interviews of suspects and the safety for all persons there. And that is an ongoing matter that is receiving the attention of the Scottish Government. Indeed, only today, my president was asked to join a working group looking at this. And I would stress that this is very important and an aspect that's not clearly covered by the bill because it's not necessarily required at this stage. But the intention, we understand, is to facilitate remote access in due course when that can be arranged. And that's absolutely essential to avoid obviously contact, and also it is absolutely essential that that perhaps looks at the role of the appropriate adult, the role of an adult attending with the child, and the interpreter, as well as the police officers, who all require their safety, as well as the legal professional in attending, and indeed the suspect himself. And these are ongoing matters that are worthy of being considered at the appropriate juncture. So that aspect is ongoing because clearly these facilities weren't in place before, as everybody would attend in close confines in a small room in a police station. So as far as the bill is concerned, prisoner custody officers are fine. There are obviously comments, if we're going to come to it, with regard to undertakings, which obviously relate a little bit towards the people who are appearing in custody. Does that help your question?
Yes, certainly. It's a very useful update on those ongoing discussions as well. Do you envisage that when they're concluded, when agreements reached on how to have those facilities in place, that would require any further change to primary legislation, or could that be achieved through secondary legislation and other practical policy changes?
Yeah, I think, again, that would be something perhaps to direct your question to the Minister and the appropriate persons. There are obviously provisions in the 2016 Act, the Criminal Justice Scotland Act, with which you'd have been concerned a couple of years ago, that refer to a solicitor being present. That's a matter that perhaps could seek clarification, but I would suggest that that question is best directed to the Minister to clarify whether any legislative fix would be required to facilitate, which clearly would be the recommended route, which is remote access being afforded by solicitors and safety of everybody that's required in connection with police interviews to be respected.
Thank you. That's everything from me, Convener.
Okay, thank you, Ross. Next questions, please, from Monica Lennon, and after Monica, I'll bring in Willie Coffey, but Monica, please.
Thank you, Convener. Good morning to our witnesses. The Convener asked a very helpful question at the beginning of Michael Clancy about the balance in terms of human rights considerations, and Michael, helpfully, you set out that this bill is largely quite technical and the impact on human rights is not in the same order as previous bills. Shona Robertson's already asked about the mental health care and treatment aspect on nomination of named persons. And I'm largely satisfied with your answer to that, Michael. But can I just ask to what extent your team looked at the cumulative impact of the other parts of legislation that are enforced? Because the named person in this part of the bill, as we know, has considerable sort of power over an individual, and we know that people in closed institutions are completely reliant on other people for their care and treatment. I am concerned that in England, the Care Quality Commission, the regulator, has in a way intervened because deaths in mental health hospitals have doubled since last year. And so that data is available, but we don't yet have that data in Scotland. So I'll have questions for the Cabinet Secretary, but how satisfied are you that we have enough data and that we're able to properly monitor the impacts of the legislation and look at it in a cumulative fashion?
I think it's probably early days for enough data to be gathered, and I would be surprised if our committee had data which they hadn't passed on in their notes to me for the purposes of this discussion, unless they thought that this question wasn't going to come up. It's obviously a difficult situation just now, where we are still getting to grips with this legislation. The Coronavirus Scotland Act 2020 is just over a month old. It's 5 weeks old since its royal assent on the 6th of April. So therefore, I think one needs to have a critical mass of operation of an Act of Parliament before one can then begin to tease out the research points and the information that's needed. It may be the case that ministers have access to information which the likes of me do not. I think it's probably more likely than not because as you will know from your interest in these matters, Ms. Lennon, that health questions are constantly being looked at, and data is being generated all the time so that there can be clear policy directions and clinical decisions. But I'm awfully sorry, but I do not have that information to hand.
No, thank you. Don't apologise. I just wondered if we need to consult further with the Human Rights Committee a bit further. Just turning to another matter then. Again, it might just be a minor point to ask, but the part of the bill, Schedule 2, Part 1, Criminal Justice, and Schedule 2, Part 2 on process of crime. I note that the term reasons relating to coronavirus it's not defined, or it's loosely defined, and I can imagine that's to ensure sufficient flexibility. But I just wondered, in your view, if you think that term is a specific enough definition. Does it need further clarity? I'm just thinking around situations where someone could say that they have coronavirus but they haven't been tested, or they won't be tested. So I just wondered what could the practical implications be around that.
Thank you very much. I might ask Gillian to cover the criminal justice elements, but clearly the phrase for a reason related to coronavirus crops up in many places in the schedule. For example, in Schedule 1, Part 1 about student residential tenancy, for example. Now, what is a reason related to coronavirus? Well, we know what coronavirus is, and one might take actions because of coronavirus which are not limited simply to being a victim of the disease or having contracted it or developed it. It might be that there is a knock-on effect because in the instance of student accommodation, the university is no longer offering the course. That is clearly a reason related to coronavirus. And the same thing might apply where issues relating to bankruptcy, there's a reason related to coronavirus because people are not able to pay their debts because they've been made unemployed or for other reasons. They may not have been sick with the disease, but the entire structure and the legal relationships and arrangements around that may well have been a reason related to coronavirus. So I'll pass to Gillian in case she has any further comments on the criminal justice matters.
Thank you.
Thank you. Yes, the coronavirus related reason is very broad, and we took from the criminal justice perspective that it was genuinely broad in the interest, if you like, of the accused, that there are all sorts, as Michael's outlined, reasons why you might not appear at court, because fundamentally this comes in under undertakings, that requirement that you get out the police station to appear in court on a specific date, but by that date you would be suffering from a COVID-related reason. So it could be carrying responsibilities, it could be you thinking of COVID, and the fact that it's not defined, if you like, with greater clarity, I think affords a discretion that allows things that we might not think about, not to define it too prescriptively. There was a point raised about whether a mental health condition would be, because I'm suffering from a mental health condition as a result of people around me of COVID or natural anxiety, whether that was covered. But I thought it was broad enough that the court, certainly from criminal justice, would be seeking not to have warrants granted where there was some reason being put forward that the court could accept that was as a result of COVID. Now, it might argue that that means that latitude would be shown in favour of the accused, which wouldn't otherwise be the case. I think that's a slim possibility, because ultimately the day of reckoning will come and they would be required to appear before the court, and effectively the provisions that are in the bill on that area are really to allow the court that flexibility and that fairness to avoid people possibly travelling at times when they should not be doing so, and respecting the government's health advice.
Thank you. I don't have any further questions. Kavira, just to correct the record, I got a bit tongue-tied at the end of my remarks to Michael Clancy. I was, of course, referring to the Equality and Human Rights Commission, not the committee. Thank you.
Okay. Thank you for clarifying that, Monica. Right, my next question is from Willie Coffey, please, and then after Willie it'll be Adam Tompkins, but Willie Coffey.
Thanks very much, Convener. Michael, you mentioned at the outset some of the basic principles that should underpin any legislation. You said it should be good law, it should be coherent, comprehensible, it should work in practice. Can you see those elements in this legislation, given that it is emergency legislation and it's had to have been derived really in a bit of a hurry to deal with this emergency situation? And where do you see, where are the safeguards for the public in the application of this kind of legislation, particularly thinking about any unintended consequences that might arise from some of it?
Thank you very much indeed, Ms. Coffey. It's a very interesting question because it goes to the heart of the job that you and your colleagues as MSPs are doing in terms of the scrutiny of the legislation. This bill contains many order-making powers, and some of those are in the body of the bill and some are in the schedules. But I think it's quite important for us to remember that scrutiny taken at speed may result in unintended consequences or unforeseen consequences. And of course, the whole point about unforeseen consequences is that no one foresees them, and that's a difficulty. But a compressed timetable like the one which this bill is being subject to, with this evidence session today, stage 1 debate tomorrow, stage 2 on the 19th, stage 3 on the 20th, is better for scrutiny than an emergency legislation under the Parliament Standing Order 9 which will take place with the entire stages of the bill in one day, as we had with the Coronavirus Scotland Bill on the 1st of April. So I think that this process is better than that process, but it still means that we have to be on our guard. We've got to be on our guard because there should be as much scrutiny as possible of this legislation, but also of the subordinate legislation that comes from it. Currently, the Delegated Powers and Law Reform Committee has 8 orders which it's considering, which are labelled as Coronavirus Scotland orders, or at least those were the 8 that I could find on the website last night. The UK Parliament is dealing with 70 orders, which are coronavirus orders. And the Hansard Society has recently done a survey of the UK Parliament's approach to this, which is quite instructive, and I'll pass that on to Mr. Johnson, the clerk, so that he might circulate it. It's an instructive piece of work, and one which I found quite interesting. One of the things which the Minister said in terms of legislation, subordinate legislation, which was being put to the DPLR, he wrote to the convener of that committee a few weeks ago, was that the made affirmative procedure was being used. And made affirmative procedure is a kind of fast track procedure for subordinate legislation, and it needs to be watched very carefully. The House of Lords Constitution Committee, in its report on legislation, said that the made affirmative procedure is often used in acts where the intention is to allow significant powers to be exercised quickly. In most cases, the Parent Act specifies which form of procedure should be applied to instruments made under it. In some cases, however, the Act may make for either draft affirmative or made affirmative procedure to be used. The made affirmative procedure is effective immediately. And the House went on to say the instruments laid as made instruments almost inevitably place a serious time pressure on those drafting them. A recent joint Committee on Statutory Instruments report drew the special attention of both houses to 3 statutory instruments which had been laid as made affirmatives. Revisions had been made to these instruments down to the moment that they were being made, and there had been a serious time pressure in the making of those instruments. So does that mean that all legislation which is made in haste has to be reflected on in leisure and the mistakes found? Clearly not. It's the Scottish Parliamentary Council's Office and the solicitors in the Scottish Government Legal Department are clearly expert at drawing up these instruments, but the speed at which they are produced and the speed of scrutiny is something which we've got to be careful about. And I'm sure the DPLR will have that on its radar. Now, what is done about it? There is the 2-month review, which is in the bill. You can see that at section 15 in this bill. It's replicated in section 12 in the Coronavirus Scotland Act and in section 95 in the Coronavirus Act 2020. The automatic expiry is a safeguard, and it's a significant factor here in section 9 of this bill, section 12 of the CSA, and in section 89 of the CA. And we've suggested in previous commentaries on the coronavirus legislation not only that the support which we give to the COVID-19 committee, which we think is a very welcome idea, and the interest of other committees, such as the Equality and Human Rights Committee, in mounting inquiries into coronavirus legislation and the coronavirus crisis generally, but also that there should be, in our view, a quadripartite interparliamentary group which could be formed to bring together the legislatures within the UK in much the same way as there was one for Brexit, to discuss some of the issues which are common themes which affect the legislation involved. So I hope that answers your question, Mr. Coffey, about the safeguards that might be there and the need for vigilance in examining this legislation and the subordinate legislation which flows from it.
Thank you so much for that really detailed answer, Michael. Convener, I think that'll probably do from me, because I think Adam Tompkins wishes to cover a similar area, so I'll hand back over to you, Convener. Thank you.
Okay, thank you, Willie. I've just seen a nod from Adam Tompkins that Michael Clancy has so comprehensively answered that last question. Nothing to add. So I'm not seeing any other members desperate to come in with any follow-ups. So in that case, can I just thank you, Michael and Gillian, very much for your time this morning. I appreciate it was a significant. Oh no, Annabelle Ewing has just caught my eye. So you have a follow-up, Annabelle. Yeah.
Yes, just really sorry. I had to put it in a while back, but I hadn't pressed another button, so I realised that you hadn't received my R request. It's just to go back to the issue of the mental health and the witnessing of the named person's signature, a very important issue. And it was just to double check my understanding is correct, now that we have the Law Society here, which is that there's no change proposed to the fact that the patient will have to put the nomination in writing, and that patient's signature will require to be witnessed by a person. So therefore, seeking to deal with any possible worries about coercion. Is my understanding correct in that regard?
I believe so, but we'll get that question checked out by our Mental Health and Disability Committee, and we'll write to you in the future.
Thank you. Thanks, Convener.
Yes, thank you, Annabelle. Right, I'm not seeing anything else, so I think that is us. So can I just thank you, Michael and Gillian, both for your time this morning. I appreciate it. It's a significant challenge when the bill was only published yesterday morning to be able to give it a detailed consideration, but you've done a very good job for us this morning and helped us on a range of subjects. So we do appreciate your time, and thank you for that. We are now going to move on to the next evidence session, and I'm going to suspend for about 5 minutes just to allow the technology to be sorted to allow us to do that. Thank you.
Convener, may I say that we're very grateful to the committee for the invitation and for being able to give evidence this morning. But of course, there is a vast team working on this, all our subcommittees and my colleagues in the policy department. So Andrew Alexander, the head of policy, Alison McNabb, Jennifer Payton, all of these policy officers were working very hard to produce the comments with their committees, and the tribute is really to them and to Gillian, who have done so much hard work in the last 24 hours, 12 hours.
Okay. All right. Thank you, Michael. Thank you. We'll now suspend. Right, welcome back. We're now going to turn to our second, which we're due to hear from Michael Russell, who is the Cabinet Secretary for Constitution, Europe and External Affairs, and Luke McBratney, who is the Bill Team Leader from the Scottish Government. Can I welcome you both to the meeting? In terms of the technology, Cabinet Secretary, can I suggest if you wish to invite Luke to speak, you just confirm that at the appropriate time and bring him in, and just remind you that because of the technology delays, if you're asked a question, if you just stop and take a breath before you answer it, that would be helpful. Before we move to questions, Cabinet Secretary, would you like to make a short opening statement to the committee?
Thank you, Convener, and thank you for the invitation to give evidence this morning and to answer your questions. The bill timetable that we're entering into for the second coronavirus bill is a little more relaxed than that of the first bill, but it is still pretty hectic. Can I just remind perhaps the committee where we are in the flurry of legislation and regulation that we've had since the start of this process? And I want to thank the bill team and Luke and his colleagues first of all. The bill team has been responsible for two very complex bills in a process of 6 weeks, and that is utterly remarkable. But of course, these bills involve a range of individuals, and they also involve a range of ministers. So from time to time, as this bill progresses, my colleagues will be coming to the Chamber or to the committee, certainly to the Chamber tomorrow, where I expect to be joined by Kevin Stewart and by Shirley-Ann Somerville. And then in terms of amendments to this bill, there will be other ministers who will wish to take part in stage 2 and stage 3. So this is unusual, but I hope it will be helpful to the Parliament and to the committee. We passed the LCM for the UK bill on the 24th of March. The coronavirus number 1 bill was passed on the 1st of April, and we are now considering the coronavirus number 2 bill. And inevitably, we've learned from those experiences. We've also had a detailed series of regulations. We started those regulations on the 25th of March, publishing the Business and Social Distancing Guidelines. 26th of March, we made and brought into force the health protection regulations, the so-called lockdown regulations. Physical distancing guideline was published on the 27th of March. The small amendments were made on the 1st of April. The regulations were reviewed on the 16th of April. On the 21st of April, we made more substantive changes, which I discussed with the committee before. We reviewed the regulations on the 7th of May, and on the 11th of May, we updated those with one change, which you are familiar with. That is all a flurry of activity. I anticipate that, of course, we will have more regulations to consider as we go forward. We also have the reporting process to put into place, and that will start at the end of this month when we start to bring forward the first set of reporting on not just the number 1 bill, but also on the number 2 bill and on the LCM. This bill is a simpler bill than the first bill, and it has a number of items which we regard as urgent. And I've just heard the tail end of Michael Clancy's evidence, and I entirely agree with him. The issue of urgency in legislation is a difficult one, both in primary and secondary legislation. We must be sparing. We must apply a judgment that the pieces of in legislation are urgently required and are needed and can only be used when they are needed and will pass out of use as soon as possible. But this bill covers those things in 4 broad topics: individual protections, the operation of the justice system, adjustments to deadlines for reports and accounts, and some miscellaneous measures. Now, the reporting on this bill is exactly the same as the previous bill. It will be coterminous with the bill. It will be set for expiry on the 30th of September 2020 and can be renewed only twice. And it will mean that the timetable for review and reporting is essentially a simpler one. And as I've said, we will start on that at the end of this month. I won't go into all the substance of the bill because I'm sure I'll be asked questions about it, but just to pick up 1 or 2 headlines. The issue of student residential tenancies brought forward by a number of members, including Green Party members, during the first bill. We have been able to find what we think is a solution to that, and that is in the bill. Shirley-Ann Somerville tomorrow will be able to talk about the Social Security, and particularly the coronavirus carers allowance, which we hope to be able to pay in June. There are key issues on bankruptcy, because debt will be, regrettably, an issue during this crisis period. I heard Annabelle Ewing's later question about mental health and the requirement to relax the need to witness a named person nomination. That is a very sensitive issue. Happy to discuss that. There are some criminal justice issues, proceeds of crime issues, intimation of documents issues, and then a range of other matters, including the matter of the UEFA European Championships and the fact that they will be postponed for a year, and we need to alter the legislation that we've only just recently passed on that matter. And the land and building transaction tax will also be dealt with here, so that people are not put out under an undue burden if they're due to have money refunded once they have sold a property. And there is a power on non-domestic rates relief, which is as yet unspecified, but might be a useful tool in the armoury as we go forward. I'm grateful to the opposition parties for making suggestions both about what is in this bill and for notification from some of the opposition parties about issues that aren't in this bill that they would like to see included in this bill. And that, you know, I've consistently said in every bill that I've been involved with, bills improve as they age, and we have a period of time in which we can improve this bill. It will not be possible to take on every issue, but certainly we will give each issue serious consideration and serious discussion. Finally, Convener, the timetable for this bill, I think, is clear. After today's session, there will be a parliamentary stage 1 debate tomorrow afternoon, the committee stage 2 debate next Tuesday morning, which could take us some time if members choose that that's what they wish to do, because the standing order preventing committees to meet while a parliament meeting has been suspended. And then we hope to have a parliamentary stage 3 on the afternoon of Wednesday, the 20th of May. And I have already written to the Advocate General, to the Attorney General, and to the Secretary of State for Scotland, requesting an expedited royal assent if the bill is passed on Wednesday, the 20th of May, so that we would have the matters in this bill that finally make it through available by Thursday, the 28th of May. And with that, I'm happy to answer questions, and I'm sure that Luke will also be happy to do so.
Okay, thank you, Cabinet Secretary. It's a very helpful summary of where we are. And I know the members have some questions on what is in the bill, and also some questions about issues that are not currently covered by the bill, but I know they're interested in pursuing as amendments at later stages. I wonder if I could just start off with a very general point, which I suspect might be in the minds of some people at home who might be watching this, and they'll have seen the announcement from the First Minister at the weekend of some relaxation of the restrictions that there are in current lockdown. And, you know, very much, I think, a direction of travel, we all hope, where we're seeing a loosening of restrictions. And they might be wondering, you know, if that is the case, and we are potentially through the worst of this, or perhaps through the worst of the first phase of it, why do we now need a new bill with more restrictions and more measures being brought in at this particular point?
Well, I think we have to apply proportionality. Clearly, it would be in our minds that the regulations may change over the coming weeks and months. I think the phrase that the First Minister uses, baby steps, and that is going to be a lengthy process. I think that has been made clear by everybody, and we have only made a very, very small change in the regulations this weekend. The powers in here will be required for some time, and we said this for the bill too. Whilst there is still major disruption, then there are some things that cannot be done, or if they are to be done, would be disproportionately burdensome, given the work that will continue to be done to protect Scotland and to take Scotland forward with the threat of this virus. I don't think even the most optimistic of us would believe that a switch is going to be flicked and we will be back into the old world. That is not going to happen. It is going to take us considerable time. And in those circumstances, what's in this bill is what we believe is required. I hope this will be the last bill. So there is that small glimmer of legislative light at the end of the parliamentary tunnel. I think that we will have dealt with the vast majority of items we feel we need to deal with. There are still issues, for example, such as a jury trial issue. I understand there's an announcement today that Lady Dorian will be taking forward a judicially led group to look at how that should be dealt with. And that has been a difficulty which is not yet resolved. There may be other issues, as Michael Clancy rightly pointed out. The thing about unforeseen issues is you can't foresee them. There may be issues coming forward, but to the best of our ability, we're trying to deal with what we need now and what we will need in the next period. The judgment about the next period can be made in terms of the legislation, either when we switch powers on and then off, or on at the end of September. And of course, the staging posts to the end of September are the end of May and then the end of July, when we can also stay, and the whole Parliament can say whether these measures are still required, whether they should be phased out, and then, of course, a decision about the whole bill, whether it should be renewed at the end of September. So I think we have safeguards in, but the answer is we need these parts.
Okay, thank you for that clarity. Can I ask, this will be my last question, I'll bring in Willie Coffey afterwards. There are some parts of this bill, including those that relate to the UEFA Act, are not directly related to the coronavirus emergency, but would have to be made whenever the championship was held. And there's also been the case with some other secondary legislation where most of the provisions related to the coronavirus pandemic, but some others also provide for other unrelated policy changes. Can you explain why you've included non-pandemic related changes in this bill relating to UEFA? And more generally, what is the government's approach to including non-pandemic policy changes within coronavirus bills or other SSIs?
It would not be our intention to do that as a matter of course, and indeed with anything major. I think the one you're referring to is a small change in the UEFA Championship bill, which I think on reflection it was decided as this would require an additional piece of secondary legislation. In any case, it might be best to save everybody's time and roll it up within what was required. The bulk of the powers in all the legislation, the overwhelming majority of the powers, are to do with the coronavirus. The UEFA Championship bill is to do with the coronavirus because the championship had been postponed for a year, as a result of which the legislation we have cannot be imposed. So we have to move it on a year. The small change that is in there is designed, I think, to save people time. If there was a rooted objection to that, then we would have to use that time out with this bill. I think that wouldn't be in anybody's interest. But the judgment we apply, first of all, is, are these items essential at this stage? And the answer in the vast majority of cases is yes. Anything else is tangential, perhaps just to save us a little time. But there are very few of those things, very few.
Okay, thank you very much. That's very helpful. I'm going to bring in Willie Coffey, please, and after Willie, it'll be Adam Tompkins. Firstly, Willie Coffey.
Thanks very much, Convener. Cabinet Secretary, you've introduced some new provisions for students in relation to terminating their tenancies that you mentioned at the outset there, and also, I think, protecting them from being forced to pay for accommodation should these restrictions continue into the new term. Could you just broadly outline for us what the provisions are that you're introducing and what issues that they'll resolve for Scotland's students?
Yes, I think there was the greatest sympathy when this was raised under the first bill, I think, by the Green Party, and I think that we would have liked at that stage to have taken it forward. There were very considerable concerns as to how this should be done, and it's one of those areas where it did require a lot of consideration as to whether it was possible to do this. Now, it has been decided it is possible, and we've brought in essentially something pretty simple. The bill will introduce a 7-day notice period for those currently tied into student accommodation and a 28-day notice period for agreements entered into while the Act is in force. Now, those are simple to understand, but they do deal with something that has been a problem. Most students, are not at university. The universities are not functioning in their normal way. In these circumstances, tying students in to these arrangements is basically unfair and very detrimental. And we feel it is right to take this step. There will be accommodation providers who are concerned about it, but we do think that this is natural justice, essentially, to be able to do so. Kevin Stewart will talk in greater detail about it and how he has found a way to resolve the issue. But I think the outcome is the right outcome at this stage. And I think it is fair that we are doing so.
Thank you for that. We know that some students haven't been allowed to end their contracts, particularly with this purpose-built accommodation providers and so on. Will Will this provision that we're introducing allow any claims of a rebate? Is that a possibility for some of the students to seek a rebate on some of that payment that they made?
The regulations do not permit that at this present stage, and I think that would be difficult to do legally as well. Of course, it is an issue worth discussing. I know Mr. Greer was very concerned with this at the first bill, and he may well wish to pursue that issue. But it is hard enough to legislate, promptly and effectively in this area. I think if you add to that most desirable outcome, but if you were to add to that burden, I think you'd find it even harder to do so. So I think this is simple, focused, and does the job that we need to do now. We can't do every job.
Okay, my only other question, Cabinet Secretary, was in the UEFA Championship that was mentioned there by the convener. I think, is it a 2-year extension to the sunset clause that we've introduced? That we know the Championship's been delayed a year. Why have we introduced a 2-year extension to the sunset clause?
UEFA is absolutely determined that the championships will go ahead. I think all we do is we create the context in which that can. There is no dubiety about that as far as I'm aware.
Okay, right. Thank you very much for that. Thank you.
Okay, thank you, Willie. The next question is from Adam Tompkins, please, and after Adam, I'll bring in Monica Lennon. Adam.
Thank you, Convener. Good morning, Cabinet Secretary. Cabinet Secretary, I welcome broadly the way in which you've engaged the other political parties in the Parliament in the construction of this bill, as you did earlier in the construction of the legislation that we passed on the 1st of April. And I want to raise with you some concerns and questions I have, not about what's in the bill, but about what's been left on the cutting room floor, as it were. And in particular, I know that I'm very far from being the only MSP who is receiving an increasing volume of increasingly anxious email from constituents about getting married. And we can all understand the reasons why we can't yet permit large wedding ceremonies and parties and receptions, but there is the world of difference between that and making it really very difficult for people to get married at all. As I understand it, although please correct me if I'm wrong, in Scots law only 5 people are required to be present for a lawful wedding: the registrar, the 2 parties, and 2 witnesses. And there are many rooms available where we can have social distancing with only 5 people present. So can I ask you why you took the decision? Correct me if I've misunderstood this or misrepresenting anything, but can I ask you why you've taken the decision not to include provisions in this legislation enabling people who need to, for example, people who are at the end of their lives or nearing the end of their lives, to get married in the way that was proposed by other parties represented in the Parliament?
Yes, I can. Let me just get the exact detail here, but it is possible for those who, because of the circumstances in which you have mentioned, let me take 2 in particular. One is end-of-life issues where people wish to get married, and also somebody who requires to leave the country, to work or whatever, and we wish to get married. It is still possible for that to happen. That is, the technical situation is that there is presently, the licenses are not being issued, but that could happen in those circumstances, and the Registrar General has the right to do that, not only to approve that, but to waive the notice period. So it is possible to do it, and I'm happy to provide the committee with a written account of how that can be done. But so therefore, a marriage is possible in those exceptional circumstances. I think the question then of whether marriages more generally should be permitted is one to do both with capacity and safety. And I think, and also to see if there were alternatives. I know, for example, that a number of people have coalesced around the idea of having marriages by video link, which is apparently been introduced in New York. I think there's a very great fear of abuse in those circumstances. And I think in those circumstances, that would only be entered into with a great deal of thought and preparation about how you could verify things. Forced marriage, for example, would be easier to bring forward if there was no physical presence there. and no possibility of assessing, as a registrar will often do, what the circumstances are. So I think the video link thing was written off. I think there was a view that as we are maintaining the lockdown as it is and not moving it with one small exception this week, it would be the wrong time then to bring forward arrangements that would loosen it in one place. I think you'd have to loosen it in a number of other places. The very, very difficult, and you and I will both have had representations about this too, funerals issue would require to be dealt with there. And I think that is difficult unless you deal with all of those things. And if you deal with all of those things, that becomes almost impossible to contain. And I think there is an issue of capacity. I mean, the registrars are dealing with issues of capacity. They are finding themselves under a great deal of pressure, particularly with the registration of deaths. There have been big changes to that. So I think what we're saying here, without any pleasure in saying it, is that it will be difficult to do for weddings. We understand the problem. It is an area which will have to be factored into the lockdown and the loosening of regulation when that happens, and we are not at that stage, I stress. And in terms of the emergency circumstances which have been raised, it is possible to deal with those, and they have been dealt with.
Well, I'm grateful for that, and I'm sure the committee would welcome, as indeed probably the broader Parliament, Cabinet Secretary would welcome clarity around what exactly the legal rules are with regard to the issues you talked about, the Registrar General being able to waive ordinary notice periods, and registrars, contrary to what certainly my constituents who are writing to me about it seem to believe, being able, within the current rules, to license marriages. As I understand it, registrars in Scotland are not currently licensing marriages. So if it is possible within the existing rules for them to do so, and if there are, exceptional circumstances in which it is really in people's interests for them not only to be able to do so, but to actually do so with regard to end of life, with regard to people who need to travel overseas and so on and so forth. Why aren't they doing so? And what should we as a Parliament in this legislation be saying to not merely mandate them to do so, but to encourage them to do so? Because it does seem to me that there is, if what you say is accurate, and I have no reason to dispute it, an unfortunate mismatch between what's happening on the ground, which is nothing, and what is able to happen on the ground, which is that in these exceptional circumstances, registrars are able to license marriages, albeit that we can't, for understandable reasons, sanction large wedding parties or receptions.
I'm very happy to provide to the committee the information I have, and indeed to seek it to be expanded, about how application can be made in a very limited set of circumstances. And the circumstances I understand them are if one of the partners, whether the people involved is dying, or whether somebody is to be about to leave or to be posted overseas, particularly in the armed forces. But I am happy to get that information to provide to the committee more widely to the Parliament. And if that is not happening, and my assurance is it is happening, if it is not happening, how it can be made to happen. I think for the rest of it, the decision was based on the issues that I've outlined, and that is, the decision that we felt it was not possible to go any further than that at this stage. But of course, if and when the lockdown eases, then obviously that is an area that people will wish to see, and for a return to some form of public affirmation, even if it is with very limited number of people, which it would have to be.
Okay, thank you very much, Cabinet Secretary. We're going to move on to Monica Lennon, please. And after Monica, I'll bring in Anne Bondieu.
Thank you, Convener. Good morning, Cabinet Secretary.
Morning.
In your opening remarks, you acknowledged that debt will regrettably be an issue and a consequence of the pandemic. So the provisions on the bill that provide greater support for people who are in debt are welcome. Can you explain, Cabinet Secretary, how you've reached the amounts that have been set out in the part relating to bankruptcy? in terms of the level of reduction that you've proposed, and also the amount that a debtor must owe a creditor before bankruptcy can be pursued. I think it's from more than 3,000 to now more than 10,000. And you might be aware that my colleague Jackie Bailey has proposed some further amendments which would give people greater breathing space around fees and other interest charges accruing. Is that something that the government is willing to consider?
Yeah, of course. And I think you're putting your finger absolutely on the key issue within this proposal, which is not that the proposal should be made, but how far the proposal should go. And I know Jackie has some views on this, and I welcome those views, and we can have a debate and a conversation about it. I think there's a number of issues in here. One is the issue of fees for bankruptcy, which have been difficult to meet for some people, and we're trying to address that within here, recognizing that debt will continue to be a real issue for people beyond when the pandemic has come to an end, whenever that is. There will be people who will have the consequences out of it. There has been limited, I would call it informal consultation with a range of bodies to talk about this. And I mean, Jackie is aware of that too, because a number of MSPs and a number of bodies have been thinking about this. And there will be different views about what level of fees and what the limits should be in both parts of this, because there are two parts to this proposal. I think that there's always a compromise, and we think this is the right compromise. We think it broadly gets support from money advisors and others. Creditors are wary of these proposals because they're wary of people who are running up debt and then cannot pay it. And there are, regrettably, some people who are responsible in that regard, and there are some people who will do it deliberately. And so creditors are wary. The debt advice bodies would also want to go further. So you have those two things sort of pulling in opposite directions. And we think what we've ended up here is probably the right compromise. But of course, there should be a conversation about that. But if there is to be a change here, it can only move against the creditors and in favor of the debtors, or the other way. So we would be moving further in favor either of those who are owed money or those who owe money. And perhaps we should try and strike a balance. But this isn't on tablets of stone. There can be a debate and discussion about that. Of course, there should be.
Thank you. That's a helpful starting point, and I'm sure members will engage in wider discussion on that. I don't know if you heard my earlier question to the Law Society. It was relating to the Mental Health Care and Treatment Scotland Act 2003 and the part of this bill that affects the nomination of named persons, so the issues around signatures and so on. I just wonder, I mean, I know on its own this is a relatively modest change, but I just wondered, because you mentioned that the bill is cross-cutting and other ministers are involved, what's been the cumulative sense so far of the other acts and regulations that have been passed in terms of the impact on human rights? And has there been consultation with the Equality and Human Rights Commission and the Scottish Human Rights Commission on the particular parts of the bill? Cabinet Secretary, you might be aware there's been some concern expressed in England about deaths of people who have been detained under the legislation, and it's doubled since last year, and I haven't seen the data for Scotland. So is there anything you can add to provide some reassurance around that?
There has been consultation with a range of bodies about this, and all of us would be very cautious here. The continued provision, I heard Annabel Ewing's last question too, so I didn't hear your full question. I came in from Cabinet just as Michael was but just as your question has been answered. There has been, I think, an agreement that this is needed, but it cannot be a power that does not have checks as well as balances. The checks are the continuation, as Annabel indicated, of the witnessing that's to take place. This refers simply to the detail of the requirement for the docket attached and signed by the named person, to have a specific type of person witnessing that as well and signing the docket. And it is the availability of that type of person on every occasion that is the issue. It may be one of these things that might never be used, or only on a very, very few occasions, because it is possible to use a default position. But if it is not possible to use a default position, then there is a problem, and it becomes a complication in, to be blunt, the lives of people who don't need complications. We need to try and keep this as seamless, as smooth, as untroubled as we can. So I think it's a proportionate power. I think it should be considered very carefully, and of course it will be reported on. And that's a feature that I just want to stress. Michael Clancy's, I think, very detailed answer about rushing to legislation, the difficulties of these circumstances, missed out a key element, and the key element is reporting. We've made a very strong commitment to reporting on all the aspects of the first and second bill, and on the aspects of the powers we were granted under the LCM, and that is an additional check, and reporting every 2 months. So if there was any tendency for this to get out of control, there's an opportunity to look at it every 2 months. Now, I've been working on the issues of reporting. I hope to bring forward some suggestions shortly, which will give the committee as well as the chamber a role in that reporting. So there is an additional check upon what is happening. We're right to look at it. We're right to look at it very carefully, and we're right to we will need to, in the reporting process, look back and see whether, as you are aware, because you've asked me about it before, parallel powers in other areas have been used, and to learn from that too.
Thank you. If I just briefly, one more question, convener. The part on carers allowance supplement in the bill is welcome again as a starting point. The Cabinet Secretary will be aware that young carers are not entitled to carers allowance, therefore they won't be entitled to the carers allowance supplement. Like Adam Tompkins, who's had casework inquiries around marriage, I've had inquiries about the young carers grant, if that will be increased, and also are there any plans to increase funeral support payments? I think the Secretary mentioned his colleague Shirley-Ann Somerville will be making some remarks in Parliament tomorrow. Is that something he could take back and discuss with his colleague?
Of course. I mean, Shirley-Ann will be proposing this. We'll be talking about it tomorrow. I'm quite sure points can be made to her. It would be nice to do everything that we want to do. It is very tough to do, in circumstances where resources are very tight. But to be blunt, the Scottish Parliament does not have the borrowing powers we need and some of the tools we need to do these things. So there are always compromises to be made. But I think the carers coronavirus grant is a big step forward. What else can be done, I think, is up to Shirley-Ann to have a conversation about that. We're absolutely aware of the enormously strong role of young carers. I think there are other ways in which we can continue to recognise that and build on it. But there are areas which I think it's always best to leave to somebody else's portfolio, and I'm sure she will want to discuss that tomorrow.
Well,
thank you very much.
Thank you. Thank you, Cabinet. Thank you, Monica. I'll bring in Annabel Ewing, please. And after Annabel, we have Ross Greer. I'm hoping we have Annabel Ewing. Annabel seems to have just dropped off. I think if we just move on then to Ross Greer, please, if you're ready, Ross.
Yes, thank you, Convener. Good morning, Cabinet Secretary. I'm interested in the issue of timescale for the expiration of provisions in the bill. You mentioned it at the start and then in answer to a couple of the questions. I don't know if you caught in our previous session, Annabel Ewing had highlighted that some of the practical changes that are being made here, for example, about production of court documents on websites rather than physically on the walls of the courts, might be the kind of things that we want to keep. There are other things where, as you said yourself, bankruptcy is going to be an issue as a result of this crisis, but it's going to be an issue long after the public health aspect of the crisis is over. So I'm wondering what the government's thoughts are, how amenable you would be to more variation in the timescales on which the provisions in the bill expire.
I think it is really important that we differentiate between what we need to do now and what we would like to do in the future. They're not unconnected. I entirely agree with you there. But we've been sort of running very, very fast to get to this position. And we've put in place things which have not been able to have the detailed level of scrutiny that you and I and the committee and others would like to see. If we are then to make some of these things longer lasting, then we need to consider two things. What further scrutiny should we give to them, because they may be able to be improved? And are they working as we intended them to work, in which case they may also need to be improved? So the short and clear answer would be the bill expires, the powers expire in all this legislation on the 30th of September. So that's it. All the powers expire. They can be renewed twice. It may well be during the reporting process that you, me, and others say, "Gosh, that's worked rather well." To take an example, to display documents on the walls of the court. I'm not disrespecting it, but it does seem not quite as relevant, as having them on a website. Maybe we should do both. So there are things that we can say to ourselves, maybe we should take that forward. But then if a member says that, and if the Parliament says we want to do that, then we need to find a way to do so. But I don't want to say that anything that we're doing now lasts beyond the cut-off date, because that would be to do something greater than we have said. But, bankruptcy is an example. I mean, we are going to have the legacy of this for a long time. So it may well be that we would want to look at what we could do to help that process beyond the ultimate cut-off date. Those are conversations we'll need to have, but they're not the conversations for today. The conversations for today are to get the powers we need now.
Thank you. And just one more question, and again, it goes back to something that you remarked on earlier. You're hoping that this would be the last of the emergency bills. There is further work to be done around the issue of solemn trials and the role of juries. In discussion with the Law Society this morning, we picked up that their president's now been asked to be involved in a working group on the facilitation of court appearances, for example, from police stations to facilitate virtual appearances and the issues around that. So what I'm interested in is what will require further change through primary legislation. If you're not envisaging further emergency bills, but we're expecting one particular further bill around justice, do you have an idea yet of what will be included in that justice bill to be brought forward? And should we be expecting a number of individual smaller pieces of primary legislation to be brought forward?
I certainly don't want to cut off the route of legislating when we need to, and as I made clear, and as Michael has made clear, Michael Clancy is making clear, unforeseen means unforeseen. I mean, it may well be that something will come forward. As I said earlier, I understand there's a judicially led group set up under Lady Dorian today to look at some of the issues, the jury issues. It may well be that they would recommend primary legislation. I don't know, but if they did, that would have to be expedited at least, and possibly emergency legislation. There may be other things coming along which we will have to react to in that way. I am saying that the sort of portfolio bills this of which is the second that I've been coordinating, I am not immediately going to say to the bill team, here's the third one coming along. I think we've done the trawls that we needed to do. We've talked to the opposition parties about what they want. But of course, if we found ourselves in a situation that we needed to do something urgently, we'd do it.
Thank you.
Okay, thank you. I'll bring in next Shona Robeson, please. I think it's got some questions around mental welfare and the carers allowance. And after Shona, I'll bring in Beatrice Bishop. But Shona first, please.
Thank you. I think the mental welfare issue is probably being covered, so I'll just ask a couple of questions around the carers allowance supplement. First of all, obviously welcoming the 19.2 million and the recognition, I think, added pressures at this time. I know that you said Shirley-Ann Somerville will be setting out a bit more detail, but I'm assuming, given the cut-off for the bill and the legislation is the end of September, that this is a one-off payment. However, would it be the government's intention to keep this under review should we end up in a very prolonged period of dealing with COVID and unpaid carers? essentially dealing with COVID and those additional pressures and caring responsibilities that they may have. Is that something the government would keep under review around potentially a further payment at a later date?
Well, I can't commit my colleague or the government to additional expenditure. All I can say is that the intention is to have the one-off payment in June. This was in addition to the a carers allowance. This is a carers allowance supplement for the coronavirus. The timescale we're working to, of course, will be extended, and it may well be that a whole range of things, financial help, will have to return to. That will be dictated by the resources available to us. I think you have to treat this as a one-off. I think it'd be unfair to people to say anything else, but of course you're entitled to raise the point, and I'm sure the Cabinet Secretary will want to think about that and to respond to that point within the limit of her abilities financially. You yourself have been in those circumstances financially, and it's always tough.
I think that's helpful. I think it's absolutely right to be clear with people around that. I think that's only fair. Is it also fair to say that in relation to carers who are not in receipt of carers allowance, that some of the other supports that have been made available, such as the additional funding for the welfare fund, could, if local authorities so wished, be used to support those carers? I know there's been an additional level of discretion given to local authorities around that. It would be helpful just to have that confirmed.
Absolutely. For unpaid carers who aren't in receipt of carers allowance, there are a number of other routes. You're right to say the Scottish Welfare Fund is one of those routes. The crisis grants and community care grants have indicated that people have been doing that. We would urge people to apply for what they're entitled, and we would want them to have that. It is really essential that we help people as much as possible, but there will be people, as there is in every scheme that we're operating presently, there will be people who fall outside it, who do not qualify for it. I'm quite sure you in the work you're doing in your constituency, as I am doing here in my constituency, are trying to find ways in which individuals can qualify, even if they failed to get the grant that they first gone for. I would say that, doubly say that to carers. We should do everything we can to help you get the resources you need, and there are other routes for those who don't get paid the carers allowance.
Okay, that's very helpful. I would certainly agree with that. Just finally, you'll be aware that the Cabinet Secretary for Health has written to the committee about a stage 2 amendment, putting beyond doubt that health boards and other bodies have the powers to purchase a care home or a care at-home service if the service is unable to continue. Is that something the government is bringing forward in the light of some of the challenges in the pandemic, or is it something just for belt and braces should we end up in a situation where a care service has some difficulties that are particularly sharp given the pressures of the pandemic? It would just be helpful just to hear a little bit more about the government's thinking here and where you think that may, if at all, end up being used.
Well, I'm still in the process of discussion with Jean Freeman about the detail of that, but I'm glad that the committee has been, as it should be, notified of the thinking that's going on. I think it is both the things you suggest. It is to make absolutely certain that the existing powers can be used when they are required. It is sort of polishing them down and making sure they're there. But it is also sharpening them so that they can come into use quickly if they are required. And I think there is a feeling that there are circumstances that may arise in which they could be required. There should be no question then of delay. We should be able to move as quickly as possible. I think it is belt and braces, but I think it is also a reaction to some of the things we see around us, which we want to make sure we're able to take action on.
Okay, thank you.
Thank you, Fiona. Next, I'll bring in Beatrice Wishart, please, and after Beatrice, it'll be Stuart Stevenson. Beatrice.
Thank you, Convener. Good morning, Cabinet Secretary. I'm interested in the thinking behind the section of the bill to do with land and buildings transaction tax that extends the time that people would have to sell their old homes without attracting the second home tax. In England, I'm led to believe that that was the case, that people had 3 years to sell up even before coronavirus. And this bill proposes an extension, which obviously will be welcome news to many, but it still doesn't allow quite enough time or quite as much breathing space as is allowed in England. And there'll be many people who, through no fault of their own, are unable to sell their old homes, especially in areas where property markets are slower, like the islands, and that can cause real anxiety. So can the Cabinet Secretary explain what the thinking is in choosing these specific timeframes? And did the government consider taking it to the same level as England?
I think the decision was made on the basis of what appeared to be, and in discussion with stakeholders, was a reasonable period of extension. You can't extend perpetually. There is an issue here about a tax that is due to be paid, and you can't avoid that forever. But it is another of those issues. Monica Lennon was asking about bankruptcy, and that issue too. It's an issue where you make a judgment. Whether this should be it, or whether you should expand it. The Scottish property market is different from the property market south of the border. The sums involved are actually smaller, by and large, than they would be south of the border. So we make our own decisions about those matters. If members wish to bring suggestions for different figures, then clearly that would be part of the debate. But it is a compromise. It is a compromise between not having income that is required and the rights and difficulties that those selling properties would have. So you have to make a choice. We've put in here what we think is the right choice. That is for debate and discussion. That is what a bill is about.
That's fine. That's helpful. That's all my questioning. Thank you.
I'll bring in Stuart Stevenson, please.
Thank you, Convener. Cabinet Secretary, I've just got one single issue to raise, and it's essentially about drafting, but it touches a bit on policy as well. It's quite complex, so do forgive me. I'm looking at the electronic signature of forms in relation to the bank, and in particular at section 10B, where we amend the Electronic Communications Act 2000, electronic signatures and related certificates, by including a version of an electronic signature which is reproduced on a paper document. As far as I can determine, and of course I'm a layperson, but the Law Society didn't suggest I was wrong when I put this to them, this is a novel provision. There are provisions, for example, in the Bankruptcy Scotland Regulations 2016 at 2.2, which says that anything that can be done on paper can be done electronically. But the primary reference that this bit of the bill makes is to the Electronic Communications Act, and it's Section 7. And Section 7 makes no reference of any kind to paper. And in particular, it requires that there be certification of any such electronic signature. Now, I'm just going to get techie for a brief second here. My understanding is that that certification is where you have an electronic signature, which is essentially a number computed from the contents, every dot, comma, and the layout of the document, combined with a secret piece of information provided by the signer and a published algorithm, and it's checkable, and that's the certification. Now, in introducing that this now may be transferred and put on paper, you lose that link between the representation of the document and the signature which is associated, insofar as they are verifying whether a change in the body of the document has not taken place, whereas the whole electronic signature is designed to prevent that happening. And I just wonder if what the drafter has actually been intending to cover is a pictorial representation of what the Law Society has described as a wet signature, which is in an electronic system and then removed and put on paper? Or was it meant to be that wider expression of a signature that I have just described? And I recognise this is quite complex, Minister, and you may not wish to give me an answer now, but certainly before stage 2, before the closing of amendments to stage 2, perhaps it would be useful if an answer is not available now.
I would dearly love to give you an answer now, but I haven't a clue what you're talking about. In these circumstances, I think it's best I don't give you an answer now, but I refer that to my officials and I will give you an answer in writing. Whether or not it is a wet signature with it or not, or a pictogram, I have no idea, but I'll get you an answer.
Thank you, Mr. Stevenson. Thank you, Mr. Russell, for that refreshingly honest answer to that last question. I think we seem to have lost Annabel Ewing for the time being. I'm hoping we can maybe get her back. In the meantime, can I maybe just ask another question about an issue that's not been raised so far in this session, that's not covered in the bill, but an issue I've raised previously in debate and with you in correspondence. And that's the issue around relaxing the licensing laws. At the moment, it's not possible to purchase off-sales alcohol in supermarkets before 10 o'clock in the morning. Now, there's very good reason why we have these licensing laws in place, but of course, that does put in an unreasonable restriction on those individuals who can only carry out their shopping in the early hours of the day, and I'm talking about people who might be in vulnerable groups or indeed NHS workers, many of whom find themselves in a situation where the large supermarket chains, indeed some of the smaller convenience stores, have set aside specific shopping times for them before 9 o'clock in the morning, so they're not coming into contact with others, which is a very, very reasonable and responsible thing to do. But it does put them at a disadvantage because it means they cannot purchase alcohol with their weekly shop, and if they want to purchase alcohol, they then have to come back into the shop another time when it's busier, and it does seem rather unfair to those individuals that they're left at that disadvantage. So I wonder if this is something that the Scottish Government have considered and whether it's something that might be looked at in terms of amendments to the bill at a later stage.
Thank you. Yes, you have referred to this in the chamber, and I know you have spoken to me about it. I mean, I have asked for advice on this, and I have considered it, and I know that the relevant health ministers have considered it, and I think the balance of opinion has been that whilst there was a concern about this at the start of the dedicated shopping hours, which is I think what you're referring to, where people were able to do so, that seems to have fallen away quite substantially, and certainly I haven't received anything on it for some weeks. There was also the view that given Scotland's relationship with alcohol, extending licensing hours wasn't something we would want to do. I think some of the stakeholder groups made that pretty clear. I think the last time you raised this in the chamber, and I indicated that it was, of course, something that should be discussed. They were quite clear about it. All I can say is it's not, as you know, in the bill as drafted. The Scottish Government, therefore, does not intend to bring it forward. If it were brought forward by others, an amendment, then the chamber would have to discuss it. I think any such proposal would have to be incredibly tightly drawn. It would have to be, as all the proposals are, sunsetted very clearly. I think it would have to be focused entirely upon those who actually simply couldn't go to a shop at any other time. And I think the range of shops involved would have to be pretty tightly controlled too, given the potential for abuse. So I think there are some very difficult technical and legal issues as well as a practical issue. But as I have consistently said, the process of legislation is about changes and discussion and debate. You have raised it several times. I think we would wait to see if anybody brings it forward or if it got support.
Okay, thank you. I think Stuart Stevenson wants to come back in presumably on that point, Stuart.
Yes, Convener, I think you can hear right. Yes, Convener, I recall that this particular provision was one that was advocated by Frank McAveety, and I believe that the arguments he deployed at that time are ones which I would wish to now having seen how it's all happened, continue to adhere to. The fact that we're in lockdown really doesn't change the argument in relation to this at all. I know that we're an important manufacturer as a nation of alcohol, but our consumption continues to be a matter of some concern. And I would be very reluctant to see this brought back at this stage, especially as it would create that longer term confusion about what the rules are. And I'd quite like to stick to the position that Frank McAveety took when this it was previously brought forward as an amendment to a pro forma bill.
Okay, thank you, Stuart. I'm not sure that was really a question to the Cabinet Secretary, but if the Cabinet Secretary wants to respond, he's welcome to.
No,
okay, thank you. Well, we can discuss this at stage 2 if it comes to that. I'm delighted that Annabel Ewing has rejoined us. You are our last viewers.
Thanks, Murdo, and good morning, good afternoon, Cabinet Secretary. Can you hear? Just checking, you can hear me.
Yes.
Yeah. Okay. So I obviously I'm at a slight disadvantage because there was a connection problem, so I'm not entirely sure what may have been covered. So if I'm seeking to repeat or ground, please let me know. My first issue concerned the issue of the local connection in terms of referrals between local authorities as regards homeless applications. There's a provision in the bill to put back the ministerial statement that was to have been produced for November 2020, which in turn was to be preceded by a statutory consultation. And this has been put back to May 2021. And it was just really 2 initial questions on that. Is it the case, well, first of all, what are the reasons for that? And secondly, is it the case that my reading of the provision is correct, that there's provision for a further potential extension to November 21? And again, what would be the reasons for such quite a long pushback? Because obviously this is a very important issue. Thank you.
I wonder if I could ask Luke to answer that. It is a complex area. I know Kevin Stewart will be talking about it tomorrow, but I know Luke, as the bill team leader, will have some more detail on this, if that's acceptable, Convener.
Yes, Luke, please.
Thank you, Minister. Extending the deadline for making the ministerial statement and therefore largely the benefit of the achieved with the opportunity to explain the required contribution, pensions to local authorities and the health sector, frontline services, much needed time and space to put this effort into responding to the outbreak. Extension of 6 months is intended to provide space to deal with these uncertainties. An important point to recognise is that this is the backstop deadline for the publication of the statement.
Luke, sorry to interrupt you, Luke. Sorry to interrupt you, Luke. I think we're all having difficulty hearing you at the moment. I don't know, there's a problem with your microphone, but we can't.
My apologies. Can you hear me now?
That sounds a little better. You want to just try talking and we'll see how that works?
Sure. I think an important point here is that the initial extension of 6 months is a backstop date by which time the statement must be made. The statement can still be published at any point up until that deadline. And the government's intention is to keep as soon as pressures on local authorities and third sector allow. In the meantime, local authorities continue to have the power under Section 33 of the Housing Scotland Act to refer an applicant if the applicant does not have a local connection with that authority.
Okay, Annabel, I don't know, did you catch enough of that to make sense? If not, maybe we could ask Luke if you could follow this up in some writing, it might be helpful to us, because I think we were having difficulty hearing you.
To explain therefore what will be the situation on the ground in the interim. I think that would be where people might have the concern, what will happen between now and then and what is happening. And my other issue, if I may then, for the Cabinet Secretary, and again I'm not entirely sure if this has been raised, is the provision on non-domestic rates, and there's the possibility of introducing a retrospective rate relief during the course of this financial year. And I just wondered, I don't know if I'll get a direct answer to this today, but is this a signal that in fact the Scottish Government is intending in the near future to come forward with such proposals, which I'm sure would be very welcome indeed from business?
I have to say that not even for Annabel Ewing am I prepared to go to the length of saying what the government's intentions were. Not that I know. It is a power, I think, which we have all thought requires to be there because it must be in the armoury of powers that we need to have to support businesses. But I have no information whatsoever as to what its usage would be, and I'm sure that that can be asked of Kate Forbes.
Thank you, and I think because I feel I've not really been able to participate in a lot of this debate, I'll probably leave my questions there, but thank you, Convener.
Okay, thank you, Annabel. I'm sorry we missed you earlier and you dropped out a bit out of the conversation. Now, I don't see any other members wishing to come back in with any further points at this stage, in which case I think I can just thank the Cabinet Secretary and Luke McBratney for their evidence today. It's been a very helpful session. Thank you for that. And we will now move into private session to consider the evidence heard and the terms of our response to the wider Parliament. And with that, I suspend the meeting. Thank you.